The flash of blue lights in your rearview mirror triggers a universal, primal anxiety. Your palms dampen. Your mind races through a checklist: registration, insurance, speed. The routine traffic stop unfolds: license, registration, the tense wait. But then it pivots. The officer's flashlight beam lingers not on your documents, but on the passenger seat or the open console. It catches the gleam of folded currency. Perhaps it's $300 from a Craigslist sale, $1,200 for rent, or $5,000 you're carrying to buy a used car. A perfectly ordinary sum for a perfectly ordinary reason. He asks to see it. Heart hammering, you comply. He takes the cash, fingers through the bills, his demeanor shifting from bureaucratic to probing. Then comes the question, delivered with deliberate casualness, a verbal hook designed to snag the unprepared. So, where'd you get all this cash? Your brain screams a desperate, internal monologue. Just tell him. It's fine. I did nothing wrong. It's from my side job. If I explain, he'll understand and let me go. If I refuse, I'll look guilty. He'll get mad. Things will get worse. This instinct, this overwhelming desire to explain, to cooperate, to appear innocent, is the precise reaction the officer is trained and hoping to elicit. It is also the single fastest way to turn a simple stop into a life-altering legal nightmare. I am here as a legal professional to tell you that in this moment, your innocence is irrelevant. Your rights are everything. And the difference between walking away and facing felony charges hangs on the next 7 words out of your mouth. This article is not speculative advice. It is a procedural and constitutional survival guide drawn from the front lines of criminal defense, asset forfeiture cases, and the grim reality of how innocent people are ensnared. We will dissect the psychology behind the question, the terrifying legal mechanisms it triggers, the exact script you must follow, and the profound reasons why having nothing to hide is the very reason you must hide your words behind the unassailable shield of the Fifth Amendment. Part 1. The Anatomy of a Trap. Why, where do you get this cash? Is the most dangerous question you'll hear on the street. To the average person, this question feels like casual curiosity or reasonable skepticism. In the legal context of a police encounter, it is a masterfully crafted trap with multiple sprung jaws. Jaw number 1. The pretextual stop and the plain view doctrine. Often, the initial traffic violation, a faded taillight, a rolling stop, speeding 3 miles per hour over the limit, is merely a pretext. It is a lawful excuse to initiate contact. Once you are lawfully detained, the plain view doctrine allows an officer to seize any item whose incriminating character is immediately apparent. Cash itself is not illegal. So, to justify its seizure and questioning, the officer must create suspicion. The question, where do you get this, is the primary tool to do just that. Your nervousness, your hesitation, the content of your answer, all are used retroactively to justify that the cash was suspicious and worthy of investigation. Jaw number 2. The waiver of your Fifth Amendment right. The Supreme Court, in Burgess v. Tompkins, 2010, made it clear you must unambiguously invoke your right to remain silent. Simply staying quiet is not enough. It can be construed as a failure to invoke the right. The officer's question is an invitation for you to waive that right voluntarily. By answering, you are not just sharing information. You are performing a legal ceremony of surrender. You are telling the state, I agree to be a witness against myself. Jaw number 3. The creation of a consensual investigation. Your answer transforms you from a detainee into the lead investigator for the prosecution. Say you answer, I sold my ATV last week. The officer now has a checklist. Contact the person who bought the ATV. Does their story match? Check if the ATV was reported stolen. Check your history for ATV thefts. See if you declared this income. Look for text messages about the sale. If any detail is off, the buyer misremembers the amount, the date is wrong by a day, you didn't have a bill of sale, your truthful explanation becomes a lie indicative of guilt. The charge is no longer about the cash. It's about providing false information to a peace officer or the now justified suspicion of theft or tax evasion. Jaw number 4. the gateway to asset forfeiture. This is perhaps the most perverse and financially devastating jaw of the trap. Civil asset forfeiture laws in most states and at the federal level allow law enforcement to seize property they believe is involved in a crime. The burden of proof is often on you, the owner, to prove the cash's innocence. Your verbal statement about the cash's source is the primary evidence they use against you. If your story is deemed weak or unverifiable, they can take the money permanently, often without ever charging you with a crime. Departments frequently depend on this revenue. Your explanation isn't just tested. It's mined for inconsistencies to fund the very agency questioning you. Jaw number 5. The expansion of probable cause for search. Your answer, or even your demeanor while answering, provides the particularized suspicion needed to escalate. He gave a nervous, inconsistent story about the cash as boilerplate language in police reports used to justify a full vehicle search, a pat-down, or a call for a drug-sniffing dog. What begins as a question about currency can end with your car's interior stripped and your belongings on the asphalt. Part 2. The fatal illusions. I have nothing to hide, and other costly myths. The trap works because it exploits deep-seated, culturally ingrained myths about police encounters. Myth 1. If I'm innocent, I should talk. The courtroom is the arena for proving innocence. The street is the arena for gathering evidence, including evidence against the innocent. The legal system is adversarial, not truth-seeking, at the investigative stage. The officer's goal is not to exonerate you. It is to build a case. Your words are the bricks. Myth 2. Refusing to answer looks guilty. The Supreme Court has explicitly rejected this. In Salinas versus Texas, 2013, the outcome was complex, but the principle remains. Pre-arrest silence, while not always fully protected, cannot be used as substantive proof of guilt in most circumstances. A skilled defense attorney can eviscerate a prosecutor who implies guilt from silence. However, a recorded, inconsistent statement is a prosecutor's golden ticket. Myth 3. The officers try to help me. The officer's primary duty in an investigative detention is not your welfare. It is investigation. His friendly demeanor is a professional tactic. The good cop in the universal good cop/bad cop dynamic that exists even when there's only one cop. He is building rapport to lower your defenses. Trust the law, not the personality. Myth 4. I can talk my way out of this. You cannot. Every syllable you offer is a potential landmine. You forget details. You misspeak. Under stress, even honest people sound deceptive. You have zero training in navigating legal pitfalls, while the officer asks these questions daily. It is a hopelessly lopsided contest. Part 3. The shield. Your precise, unwavering, non-negotiable response. Here is the script. Memorize it. Practice it. It is your incantation against the loss of liberty and property. The sentence. Officer, I choose to remain silent on that matter. I do not consent to any searches. Am I free to leave? The breakdown. Officer, polite, respectful, maintaining civility. I choose to remain silent. Unambiguous invocation of your Fifth Amendment right. The word choose is powerful. It shows deliberate, knowing exercise of a right. On that matter, critical. It scopes the invocation to the investigative line of questioning, preventing the officer from later claiming you're being generally uncooperative or hadn't invoked your right clearly. I do not consent to any searches. Immediate, proactive invocation of your Fourth Amendment right. This blocks the "do you mind if I look?" question before it's asked. If they search after this, any evidence found faces a high bar for admissibility. Am I free to leave? This is the control question. It forces the officer to either let you go or, if he continues to detain you, legally articulate a reasonable, articulable suspicion of a crime. A suspicion he can no longer base on your refusal to explain lawful cash. What this does, it stops the interrogation in its tracks. It severs the link between the cash and your personal testimony. It raises the legal bar for the officer to proceed. It preserves every possible legal argument for your defense attorney later. Part 4. The aftermath. Navigating the pressure. Saying the words is half the battle. You must be prepared for the psychological counterattack. The officer's likely responses and your countermoves. Pressure. Why won't you answer? If you have nothing to hide, this is easy. Your response. Polite silence or a repeat. I've chosen to remain silent, officer. Implied threat. It'll go a lot easier on you if you just talk to me now. We can clear this up here. Your response. Understand. Easier means easier for them to convict or seize. Your path to easy is through silence. Respond. I understand. I'm still choosing to remain silent. Frustration/anger. You're making a big mistake, pal. Your response. Do not engage. Do not apologize. Your rights are not a mistake. Maintain calm, quiet compliance with orders, step out of the car, etc., but do not revert to talking. The direct order. I need you to answer my question. Your response. This is critical. You have no legal obligation to answer. You can say, with all due respect, officer, I am invoking my right to remain silent. If they arrest you for obstruction or failure to comply based solely on this, a competent attorney will have it thrown out. Comply with lawful orders like exiting the vehicle, but not with the unlawful order to speak. If you're arrested, the script expands, but the principle contracts further. State clearly, I'm invoking my right to remain silent. I will not answer any questions without my attorney present. I do not consent to any searches. Then become a statue. Do not fill the silence in the squad car. Do not make small talk with the booking officer. Do not complain to your cellmate. Every word is now evidence. Part 5. Beyond the traffic stop. Other venues of financial interrogation. The principle is universal, but the setting changes. Airport security/TSA. If a TSA agent or law enforcement officer at security asks about large cash in your luggage, the same rule applies. They may have a right to inquire for reporting requirements, over $10,000 internationally, but you're not required to give a detailed origin story. I am traveling with it for personal reasons is sufficient. If pressed, I choose not to discuss that further. Home searches. If officers are in your home with a warrant or by consent and find cash, the question will come. Your response must be the same, even in your own living room. I choose to remain silent on that subject and want my lawyer. Bank deposits/withdrawals. Structuring, breaking up deposits to avoid the $10,000 currency transaction report, is a crime. If your bank manager or a law enforcement officer calls about your transactions, do not explain over the phone. Say, I will have my attorney contact you. Banks are required to file suspicious activity reports, SARs. Your verbal explanation becomes part of that permanent record. Part 6. The legal foundation. Why this advice is not opinion, but law. This advice rests on bedrock constitutional principles. The Fifth Amendment protects against compelled self-incrimination. You cannot be forced to be a witness against yourself. The Fourth Amendment protects against unreasonable searches and seizures. Seizing cash based on a hunch fortified by your pressured statement is often unreasonable. The 14th Amendment guarantees due process. Having your property seized without a criminal charge, based on your own coerced statement, is a due process violation. Case law like Hybel v. 6th Judicial District Court upheld stop and identify statutes, but did not create a general duty to answer investigative questions. Florida v. Bostic defined the consensual encounter, which you end by asking, am I free to leave? Your right to terminate the encounter is powerful. Conclusion. The ultimate mindset shift. Carrying cash is not a crime. Yet, in modern policing, it is treated as a symptom of crime. You must undergo a fundamental mindset shift. The goal of the police encounter is not to emerge unarrested. It is to emerge unincriminated. You could be arrested and later released with apologies. But a statement you make can never be taken back. It is etched into the police report, the prosecutor's file, and the co. Your wealth, your freedom, and your future are too valuable to entrust to an impromptu, street-side interview. When the blue lights flash and the question comes, where do you get this cash? Your response is not an answer. It is a defense. It is 7 simple words that place the Constitution itself between you and the power of the state. Officer, I choose to remain silent on that matter. I do not consent to any searches. Am I free to leave? Say this. Say nothing else. Then live to fight the battle in the only place designed to protect you, a courtroom with a lawyer by your side. A question for you. The most common pushback to this advice is, but won't that make the cop angry and more likely to arrest me? Based on the legal realities explained here, why is enduring that short-term anger and potential arrest actually the safest long-term strategy for an innocent person? Share your analysis below. Note, this article constitutes general legal information and does not create an attorney-client relationship. For specific legal advice, always consult with a licensed attorney in your jurisdiction.